Today we are discussing the importance of medical record management, including legal obligations, codes of conduct covering patient records, and key things for doctors to remember. My special guests are David Maddox and Dr. Owen Bradfield. Mr. Maddox is a senior lawyer and a partner with Perry Maddox Trellope, and Dr. Owen Bradfield is the Chief Medical Officer for the Medical Indemnity Protection Society, which sponsored this podcast. He is also a general practitioner and a lawyer. Mr. Maddox and Dr. Bradfield, thank you so much for joining me today.
Thanks very much, Sam. Glad to be here.
Thanks, Sam.
And Dr. Bradfield, I'll start with you. What are the fundamentals of patient health record management?
Sure, thanks, Sam. So most doctors would be aware just how important medical records are as a clinical tool. Maintaining clear and accurate medical records is essential in supporting safe and high quality care. They're fundamental in ensuring that doctors can keep track of the care that they're providing to their patients, but they can also help other practitioners or members of the treating team to understand past treatments or diagnoses that can then help to support the safe ongoing care of the patient. And they also serve as a means of documenting the details of a clinical interaction or a course of treatment in the event that questions are subsequently asked or issues are raised about that treatment. And so, if the treatment needs to be reviewed. So essentially, they support really continuity of care. They support good, safe clinical decision-making. But they're also useful for, research purposes, quality improvement purposes, and also for public health surveillance. So they serve a number of different purposes.
And Mr. Maddox, what constitutes a failure in record management?
There are a number of ways that there can be a failure in recording. As examples, a failure to report or record important verbal discussions about procedures, risks or complications, or treatment options, details about physical examinations, tests or treatments, and particularly risks. And generally, the content needs to allow for a seamless transfer of care should another doctor take over the management of that patient. So they're really some of the examples of failure. In legal practice, I've had a number of cases where failure to keep adequate records has really made a defence very difficult in circumstances where it might otherwise have been quite defensible. Just as one example, unless a consultation has got something quite specific or out of the ordinary, or attention is drawn to that consultation shortly afterwards, a doctor is unlikely to have any specific recall of a routine consultation many months or years later. And so if their records are inadequate, it makes that defence very difficult because they simply have no recall, as you would expect, and you're relying on their usual practice, and that just makes it difficult.
And Dr. Bradfield, what are the codes of conduct that cover patient records?
The laws and regulations that touch on medical records are I would describe as sort of complex and numerous. And I think it's probably beyond the scope of this podcast to delve into all of them in detail. But I think the starting point for thinking about medical records, as with many aspects of clinical practice for doctors, would be the Medical Board of Australia's Code of Conduct. And so I think the Code of Conduct, from my perspective, really serves to emphasise and to remind medical practitioners of the importance of keeping accurate, detailed, up-to-date and legible records that they hold securely. It also talks about what to do if you need to amend or add to an existing record, and the importance of dating any changes or additions to the medical record. And it also sets out the importance of respecting patients' rights to access information that might be contained within their medical record, and for facilitating access to patients' records to other health practitioners who may be involved in the patient's care. And so many of those sort of legal obligations that the Code of Conduct intimates to can be found in the Commonwealth Privacy Act or in various state-based health records legislation and and I think David will touch on some of that.
The code of conduct, as a lawyer, it would be obviously one of the first documents I would look at when I'm reviewing records if there's a query about the adequacy of those records. So they're pretty fundamental. There are 9 points in the code, and I'd certainly recommend that practitioners are familiar with those codes.
Yeah, absolutely. And I think certainly whenever there's a concern raised by a patient about the quality of care, or if the medical board is reviewing a complaint and looking at the records, certainly if the board feels that the records are insufficient or do not meet the requirements of the code of conduct, then that can also be sometimes a separate and additional concern that the board may have in relation to the care provided to the patient.
And that's exactly right. There are many cases that I've been involved with where there might be a notification or concern about the performance or treatment or conduct, and when the medical board have had access to the medical records, they will add in additional allegations about insufficient records and so on. So it is, yes, significant.
Absolutely. And I think as well, the other important source of perhaps legal definition or guidance around medical records for me would be the health insurance regulations. So when a doctor bills Medicare for services rendered, the health insurance regulations require that services rendered are supported by an accurate and contemporaneous record. And those regulations sort of define an adequate and contemporaneous record as including the name of the patient, requiring that there be a separate entry for each patient attendance, that the date on which the service was rendered is recorded, and that the record includes sufficient clinical information to explain the service that was rendered. And interesting, it also goes on to say that the record must also be completed at the time or as soon as practicable after the consultation, and that the record must be sufficiently comprehensible to enable another practitioner to effectively undertake the patient's ongoing care in reliance of that record. So it's sort of quite technical language, and I was reading from the regulations, but I think what it serves to highlight as well is that the record has to be clear, legible, up to date, and written as close to the time that the service was provided as possible. And if that's not possible, if there's additional information that you need to add, or if there's some delay between the time that the consultation occurred or that the service was rendered and when the record was created, or when the entry in the record was made, it's always good practice to ensure that there's some explanation for why there's any delay between the consultation and the making of the record.
And Owen, the point that you make about continuity of care, in virtually all the cases I've had that have been referred to APRA in recent times, when they investigate and they're assessing those records, invariably one of the first comments they'll make is whether the records would enable that continuity if someone else came and took over. And I had a recent case where it's a sole practitioner and he was still operating on handwritten records. And his response initially was, well, I'm the only one here. It only matters if I can read those records. Well, that's clearly not the case. And they were, obviously appropriately insistent that the records must be in a form that enables that continuity should someone else come along.
And I think that extends not just to handwritten records, but also to electronic records. Certainly, I've assisted doctors in the past with having to look at records for whatever reason, and whilst they're electronic records and I can read the words don't necessarily make a sentence that I understand. And so I guess that also is important when it comes to ensuring that records are comprehensible for another practitioner. So having odd words that might mean something to that doctor might not mean something to another health practitioner that takes over the patient's ongoing care.
And Mr. Maddox, when can records be accessed or disclosed?
Fundamentally, under Australian privacy principles, records can only be used or disclosed, or personal information, for a purpose for which it was collected. So in terms of medical practitioners, there is no issue exchanging health information with other treaters where necessary to facilitate patient health care, including specialist letters. If a medical practitioner needs to disclose information for another purpose and they don't have patient consent, they need to stop and consider, and even consider contacting MIPS for guidance, particularly if it's for reasons such as dealing with a third party request, such as a request from police, a coroner, or subpoena by a court, or if they have concerns about patient or public safety. It's a difficult area, those last couple of points, and whether the doctor can disclose that information can be very fact dependent. For example, they cannot always disclose information to the police, and it would be wise to get MIPS guidance. I had a case only a couple of years ago where the police were trying to effectively track down a person who they believed had engaged in criminal conduct, and they arrived at the GP's practice demanding copies of records. Now, that was a messy situation. Could it relate to public safety? Maybe, but in the circumstances, our concern was it was simply intended to try and get an address or track down this person. So it's a good example that it's not always straightforward, and it may well have been that if the doctor had immediately provided those records, could have been in breach of privacy principles.
And just the only other thing I would add as well is for those doctors, particularly junior doctors who are working in public hospitals, in addition to all of the legal requirements and laws and legislation that we've talked about so far, it would also be important to ensure that you are aware of any local policies or procedures within the hospital, and to ensure that you follow those guidelines, and where you're in doubt, to speak with those within the hospital.
Mr. Maddox, where could patient records end up?
Sam, they can end up in any number of places, obviously with the patient or patient solicitors, with the medical board, which we've already touched on, in civil courts, criminal courts, drugs and poisons authorities, Medicare professional services review, in terms of billing practices, Human Rights Commission. We've had cases where patients have made notifications or complaints to the Human Rights Commission about discrimination in terms of references in the records, for example, to religion and so on. Health insurers, work cover, TAC authorities, the coroner's court. So there are any number of places where records can end up, and they all have their specific, I guess, issues that need to be considered. One issue that Owen and I have spoken before about is circumstances where parents of a child might disagree on whether those records can be provided. For example, one parent gives consent and the other doesn't. So, Owen, I wouldn't mind throwing to you on that in terms of MIP's specific experience about those circumstances.
Yeah, thanks, David. I mean, certainly there are a number of sort of patterns that we see when it comes to questions or queries that our members have in relation to medical records, and certainly one of those is in relation to parents, perhaps parents who are separated and may have differing views about the treatment of their child, or perhaps simply one parent has requested the record and the doctor is unclear whether they require the consent of the other parent to release the child's records. And so essentially the starting point in those situations is that each parent has equal and separate rights to access the child's records, provided that there are no court orders or parenting orders that remove any parenting rights or responsibilities from either parent. So sometimes situations can arise where perhaps there's been family violence, and family violence or suspected family violence in and of itself is also a reason under the Family Law Act to not release records to a particular parent. But in those sorts of tricky situations, a lot does turn on the specific facts of the case and the parent's situation and the nature of the information being requested and so forth. So it's very important in those situations to get advice from your medical defence organisation, and particularly if there is a court order or a parenting order, it'd be really important to ensure that that you get someone with legal experience to have a look at that and to assist you in interpreting that. So that's certainly one pattern that we see, is when it comes to parents who perhaps disagree about access to their child's records. I think perhaps the other pattern that we often see as well is in relation to independent medical assessments. And they are sort of slightly different, because the purpose of an independent medical assessment is often for, documentation or confirmation of a patient's diagnosis or prognosis, or perhaps to offer an opinion about whether or not a particular condition may or may not be work-related. And so it's often less about treatment, and the purpose of the consultation is often not sort of strictly therapeutic. It's more for another purpose, such as for a work cover claim or a transport accident claim, for example. And so sometimes we see that there can be confusion around what the doctor's obligations or responsibilities might be in those settings. And I think it's really important just to highlight that everything that David's already mentioned in terms of patients' rights to access records and the circumstances in which those records can or should be released also apply. So essentially, if a doctor has examined a patient for the purposes of an independent medical assessment, and they've been engaged by a solicitor or an insurance company, or perhaps by a transport accident commission or agency, and the patient then changes their mind and doesn't wish to proceed with either the assessment or with having that report released or any information about them released to that third party, then the patient still has the right to refuse that, and all of the rights and obligations that David's previously mentioned under other legislation would still apply. So they're probably the main patterns that we see, Sam.
And Mr. Maddox, what would you like to add?
Sam, yeah, a couple of things I would add is that certainly the increasing use of electronic records, I think, is a significant risk reduction step, because I've certainly in the past had one particular case that I won't ever forget, and it was a practitioner who was handwriting records, and in the course of the legal proceedings there were interrogatories served, which are part of the process where the other side can ask questions. One of the questions was, could you provide a transcript of your records? And the practitioner could not read his own handwriting, nor could his assistant, who'd been working with him for many years. So it was at best embarrassing, but at worst fatal to our defence when we couldn't actually provide a transcript of what was written in the record. So electronic records is a significant advancement, I think, in risk management. The other phenomenon that's developing, I think, is, and I'm not sure about the answer, where patients might communicate with the doctor with texts or emails or otherwise online. And that's becoming more common that I see in the doctors that I'm working with. And there's a real risk that records aren't maintained when information is coming from a number of directions. I, as a lawyer, find exactly the same problem. And I might have doctors, in fact, it's very common now, that they will, once they have your mobile number, they might send you texts, they might send you emails. And it's got to the point where, in some instances, I've said, I do not want communication by SMS, for example, because it's tedious, time-consuming to then somehow print out and document those communications. So I think that that's something that there's a risk there about adequacy of medical records when information's coming from those various sources.
And in terms of take-home messages, Dr. Bradfield, what are some key things to remember?
There's a very well-known adage when it comes to medical records, which is that good records are a good defence, bad records are a bad defence, and no records are no defence. And I think it serves well to remember that. I guess the question that I'm often asked is, well, how much do I need to document and why? And that's a very difficult question to answer, because obviously it depends on the specific circumstances of each situation, of each consultation. But I do think just looking at the Medical Board of Australia's Code of Conduct, it does set out very nicely what's expected. I think that's a great starting point.
And Mr. Maddox?
Yes, Sam, just some general comments. I think avoiding any judgmental comments in records is important, because with various health systems offering increasing access to patients to records, that is certainly an area where patients can become quite sensitive to what they might perceive as judgmental comments. There's a fair bit of literature about the sort of comments and notes that might upset patients where there are factual errors, or if there are surprises. For example, the patient learns from their records about a diagnosis that they might not have been told about, where they feel that they've been labelled or judged. For example, the use of the term obese or misgendering are areas, or if the records are somehow, they perceive them as disrespectful. So whilst you avoid judgmental comments, our observations and statements of fact are acceptable, but that's just an area I think with increasing patient access, I think practitioners need to be aware of. Owen touched on it before. As a lawyer, from my work, it's fundamental that the practitioner doesn't alter records, or if they do, that they record the date of the alteration and so on. So it's made quite clear when that alteration was occurred. And as a general comment, less is not more. So I think that records do need to be sufficiently detailed to enable a defence to occur or information to be provided to patients.
And Dr. Bradfield, what would you like to add?
Perhaps the other thing that I've seen a little bit of in my time having assisted doctors with claims and complaints that relate to medical records is where a junior doctor who might have accessed records, so they're working in a public hospital and they've accessed records in relation to a patient of the hospital who isn't necessarily a patient that they are caring for. So it might be that perhaps somebody they know personally, or somebody who is a well-known public figure, is admitted to the hospital, and then staff within the hospital have then accessed the record to have a quick look and see what were they diagnosed with, what were the circumstances of the injury, if it was an injury. And so I think it's just really important to remember when it comes to accessing health information, there has to be a legitimate clinical purpose for accessing medical records.
Mr. Maddox and Dr. Bradfield, thank you so much for joining me today.
Thanks very much, Sam.
Thanks, Sam.
My special guests have been David Maddox and Dr. Owen Bradfield. Mr. Maddox is a senior lawyer and a partner with Perry Maddox Trellope, and Dr. Owen Bradfield is the Chief Medical Officer for the Medical Indemnity Protection Society, which sponsored this podcast. He is also a general practitioner and a lawyer. You can find more podcasts on our website at mja.com.au